Okay, so we are going to follow the rule of three. We currently have 4 2/3 trilogies, which is even more ambitious than Star Wars. But our first trilogy is Mike Rappaport, Larry Alexander, and John Stiniford.
Before did you ever hear my story with Posner and the oath, when I ran the oath argument with Posner at Loyola? Did you hear about that?
I've heard various hearsay versions.
Well, maybe some guy in the queue will ask me to tell that story.
And now we have 5 trilogies. So Mike Rappaport, Larry Alexander, John Stiniford.
So I very much like the paper, except the small portions that criticized us. Read Chelsea. And I don't necessarily disagree with the basic position. If we talk about in the constitutional context and the idea that the what you call the law of interpretation was common law or general law, I don't necessarily agree with that. It could very well be the case. I would think it also, under our terminology, would be part of the meaning that would contribute to the meaning of it, and so I'm fine with that. But of course, it might not be that the common law operates, and I guess I wanted to ask a couple of questions about that. I've mentioned some of this to you guys before, but so if the general law operates against the Constitution, there is questions that often come up about how can the general law operate in our federalism system, and wouldn't state law take priority? And the general take seems to be that state law would not take priority if, at least amongst originalists, if the Constitution or federal statutes displaced it. And so the first question that I have is something that you really don't talk about, really would have been difficult for you to talk about. Sort of, how do you fit into your sort of understanding of sort of federalism more generally, the general law here, if there were a state statute that said interpret the Constitution in a contrary way, would that state statute apply in state court? Would that state statute apply in federal court? So that's one question I have about the background general law. I guess a second one, and a sort of quicker one, is you say that it won't change, or that it shouldn't change. Given that there is this sort of understanding that the general law may change, I was wondering if you could sort of say a bit more about that. From my perspective, even if the general law exists, it would have contributed to the meaning of the Constitution, and so even if it changed, it wouldn't change the meaning of the Constitution, because that would have been fixed at the time of its enactment. But I'm wondering what you guys think.
Rule of three. The second movie is Larry Alexander.
I gave Will and Stephen my long version of a question, so I'm not going to repeat it. I hold a fringe position even within the fringe group of originalists that we are, and so simple picture. I'm a simple guy. Give a simple picture. I'm a proponent of the standard picture, right? So that seems to be out of favor. Mark Greenberg and I have argued about the standard picture. So, why do we have law at all, constitutional or otherwise? Well, the simple story is we have a lot of controversies about what our first order practical principles require us to do, and those controversies have moral costs if they're not settled. So, law comes into the picture as a human artifact to settle controversies that need to be settled. There's a problematic relation between law and the stuff it's supposed to settle. That's been, some of us have written about that. But suppose you take that as the function, law is to be settled presumably wisely, and so we want people to reason about what the norms will be and then come up with the norms. We choose, and in a democracy we choose those people, and in a constitutional convention we have certain people with certain authority to choose those norms. My view is that the norms they choose are the law, and so let me just reference an article 20 years ago or so of my colleague Steve Smith called "Law Without Mind," and it was in response to a proposal by I think Alex Alenikov, if I recall, who said that the words of the statute should be interpreted according to whatever the dictionary meanings were today. So not at the time the statute was enacted. So that, the statute could change in the sort of mindless way that the meanings of words change over time. And Steve rightly pointed out, he was critical of a view, and that's the title, Law Without Mind. And I think the idea that what we should have is mindless law creation. So we have a picture of people picking the norms, but then those norms go out into the world, and they're acted upon by other mechanisms which are not mindful. They are mindless, and they produce something that wasn't intended by the people we chose to make the norms. So there are lots of these two-level pictures running around the room, and I reject all of them. And so, and yours is the latest version of that.
I'm so glad you asked the short version of the question.
You are glad, because I've got a long one.
John.
Let me just say I'm really glad I made it into the first trilogy, although Return of the Jedi was my least favorite. So first of all, let me say I am not just sympathetic, but I'm super duper sympathetic to your project. But I want to point out one possible difficulty that's working off of some of the comments that have already come, and that's, I guess, your choice of Hardian positivism as your sort of framework. I think about Hardian positivism as sort of like Santa Claus in the movie Elf, right, where Santa Claus only has power so long as you believe in him, and when you stop believing in him, he loses all power, right? So I would suggest that we live in a world where the canons of statutory construction are like Santa Claus when no one believes in Santa anymore. And that's a problem from your perspective. And I would just, to point that out, I'd just simply say, and Will and I talked about this a little bit, there was a big attack on the canons in the early 20th century. The proto-realists and the realists attacked the very notion of these canons, the rationality of the canons. And you can see the effect of that by looking at Sutherland in the 19th century versus Sutherland today. Sutherland in the 19th century is very rational, very hierarchical, very well constructed. Today it's just a mishmash, right? And that's how judges use canons today. They use them sort of when they want to as icing on the cake, but not in any real sort of legal sense, right? And so if that's the case, if I'm correct that we live in a world where no one believes in Santa Claus, right, then you can't use Hardian positivism to get to a law of interpretation. I think that's a concern I have.
So can I just take a quick thing to the last point? So obviously part of the challenge of writing papers that tread anywhere near jurisprudence is we feel the need to lay our jurisprudential cards on the table, but we also want to write for people who don't necessarily share them or for people who have deep disagreements about how these things work. So part of the hope is that, the first 3/4 of the paper work regardless of whether you buy that or not. And just to telegraph what will come, I mean, Steve and I are both harsh and positivists. That's part of the reason the paper is written with that perspective. And frankly, we find it hard to get inside the heads of people who aren't. And so it's very hard to fairly write papers that do anything else. But we're weird harsh and positivists in that, as we both have written elsewhere, we don't think exactly that we're at that level of Santa Claus yet. So the fact that like a bunch of people now have like lots of sort of chaos and loosey-goosiness about the canons or even about constitutional interpretation, heaven help us, doesn't mean that we have no law in our view, because we do think there is still a widespread Santa Claus type belief that the law goes back to the founding and that you can keep looking backwards for legal pedigrees. So that'll actually give us more points of agreement with what is later said about enduring originalism. But I'll just say that.
Yes, Virginia.
I would say on the Santa Claus point, sort of like what's wrong with Santa Claus in the sense that in the sense that it's sort of surely true that like the grammar rules of English lose their power once people stop believing in them. You know that the Tsarist Russia lost power once people stopped believing in them. It seems like that's a relatively paper money loses its power once people stop believing in it, but nonetheless is very real for the moment. And I'm not sure that that's we've gotten to the point where it's lost yet. In agreement with Will. On the first 2 points, let me take them in reverse order. With regard to Larry's argument, I think you're absolutely right. There's a degree of mindlessness here. Mindlessness is not the worst thing. You could imagine a society, that sort of Elena Kovia, which would say, look, we want anyone to be able to pick up our statute book and know what it means, so therefore the law will change according to modern dictionary definitions because it gives us this other advantage. Now, I think that that's a bad system, and it will lead to all sorts of terrible things. But you could imagine a society making such a choice, and they're just balancing the disadvantages of less mindful law with the advantages of being able to understand it more easily, or whatever else you're getting. And so our point is that the law of interpretation already in private instruments and other contexts does balance things like that. Sometimes the law that's produced by particular authorities may or may not contain the legal norms they wanted it to. But hopefully that's for reasons that explain why we have all these other legal rules in the system that cause it to be thus. And in any case, whether or not those legal rules are actually justified on a first best level, they may just be the legal rules that any particular system has. And so it's just a defect in the legal system, but not one that makes it no longer the law. I think the most fundamental challenge offered by the McGrath report is sort of where does this general law come from? How do you have it in the federal system? What happens to state statutes? We, and particularly I, plan a lot of further work on this, on where the general law comes from and what role it plays in the United States. I think that a good example would be something like an example used before, the law of state borders. So when we're trying to figure out where the borders between states are, courts use all sorts of weirdo old international law rules about, accretion and avulsion of rivers, and what happens if there's an island in the middle, and what if the Thalweg or the main navigational channel shifts due to a flood, and sort of all sorts of crazy stuff that's nowhere in the Constitution. And the reason that they apply it is because there's jurisdiction given to federal courts to decide suits between states, suits involving land grants from different states, and they have to figure out where the state border is, and this is the law that would have been applicable at the time of the founding as between separate sovereigns, between the different states, and they sort of look to all the other sources of law that might apply and sort of fall through the gaps to land on the general common law. A state could, by statute, just announce that it owns the whole river, or just announce that it owns all of New Jersey, but that doesn't mean that the court would necessarily pay any attention to them, because first, in the Rules Decision Act, you apply state statute laws in several states in cases where they apply. It presumes the existence of a general law of conflicts that tells you when you pay attention to state law and when you don't. We think that with respect to something like the construction of the federal Constitution, those sort of general conflicts principles would direct you to general law rather than the statute law of a particular state, that no state has the power to alter whatever the content of the Constitution was upon its adoption, precisely because of the Supremacy Clause. The Constitution does whatever it does, state law notwithstanding, that the state law can't overwhelm the federal Constitution. And so it cannot be deliberately altered necessarily in that way. Congress may not have power to deliberately alter it with respect to sort of rules that are already in existence when we're talking about adoption rules. And it wouldn't necessarily change as the general law changes over time. So you could imagine, the rule against perpetuities might, in a common law system, change in various ways over time. That wouldn't necessarily affect the validity of grants a long time ago because of our understanding that those grants did whatever they did at the time that they were made and had their legal content at the time. If you subscribe to that kind of view, then the Constitution had its legal content according to the adoption rules that existed at the time. And even if those adoption rules have since changed in whatever way that general law changes, whether in the sort of grammar-like way or some other way, those changes wouldn't necessarily have any effect.
Okay, well, we don't want this to be so much like Star Wars that the first trilogy is great and the second trilogy is awful. So in order to make sure that doesn't happen, I have chosen 3 excellent people for the second trilogy. Larry Solomon, Jamal Green, and Naomi Rao.
Thank you, Tom. First, I want to say that I am entirely in agreement with what I take to be the central goal of the paper, which is to create the rule of law in the construction zone through the law of constitutional construction. I think that that's absolutely the right way to go. And there are different ways to go there, right? And original methods, originalism has a slightly different approach, but it seems to me that this is the direction we want to be heading in from an ecumenical perspective. And I just want to also say thank you for being very careful about terminology and the interpretation-construction distinction in particular. I think that it's just really helpful in this regard to do what you did, which is to go back to the great early 20th century treatise writers, and in particular Corbin, right, and to recognize that the interpretation-construction distinction was not invented by Keith Whittington or Jack Balkin. It's an integral part of traditional American legal theory. So I also have a suggestion for you, and the suggestion arises out of the discussion in the paper of the difference between common law and stare decisis, between common laws, you conceive of common law, and sort of just pure judge-made law or judicial legislation. And in particular, I would like to suggest that the paper might be enriched by a explicit discussion of horizontal and vertical stare decisis, because that is the implementing mechanism by which the law of interpretation and construction, or in my preferred terminology, the canons of construction get applied. And I want to say that there are problems here, both in the horizontal and vertical dimension. So horizontal stare decisis, right, the current positive law, I don't think is in the kind of shape you would like it to be in. Right, we're all familiar with the problems with the doctrine of horizontal stare decisis in the United States Supreme Court, and even the rule, the articulated doctrine of horizontal stare decisis in the Supreme Court, it does not have perhaps a very strong rule of law component. It depends on, you know, how you read that per curiam opinion in Casey, but and in practice, and I know you're very concerned about the difference between sort of the articulated norms and the way that they are implemented, and in practice it's worse than that. Of course, in order for the law of interpretation to work, this is not just a problem at the Supreme Court level, it's also the problem for the doctrine of horizontal stare decisis within the circuits. And I think you ought to be disturbed, therefore, by the recent development in the Seventh Circuit to abandon the law of the circuit rule and adopt the rule that individual panels can override the law of the circuit if they have good reasons for doing so. The law of vertical stare decisis is similarly disordered, right? So there are at least 3 major theories of vertical stare decisis that operate in the federal courts. I only know this because I have a treatise on this topic. There is the traditional theory of the ratio decidendi, right, which I think is the version of the doctrine that would be nice for you, but it is actually the least used version of the doctrine. Courts also use a doctrine of vertical stare decisis that was articulated by Arthur Goodhart in his famous articles in the 20s and 30s. This is the salient legal facts theory, that a holding is limited to the salient legal facts on the case. Notice that that makes it impossible to develop a binding law of construction because the salient legal facts theory will never enable you to get a set of holdings that define a well-articulated body of the law of construction. And then the final theory, which might be the best for you, but has problems of its own at the horizontal level, is sort of the idea that we hold that statements become law, you know, because they provide the best prediction of what the courts will do in the future. But unless there is an implementing set of ideas about vertical and horizontal stare decisis that can actually make your theory work in practice, then I think you've got a big problem. So this is not an objection. It's just a suggestion that this is a problem that the paper might want to address and solve.
Thanks. Two questions that I'll try to ask succinctly. One is, if you could say more about the role of publicity in light of your Hartian positivism. I understood your other work to suggest that you care a lot about whether legal actors publicly speak as though the law is a certain way, is thus and so, or has certain content. But here you're saying that the lawness of interpretive rules doesn't depend at all on whether the drafters know the law. And I gather that you think those views are consistent. One way in which they might be consistent is if the drafters are not part of the relevant legal community. That might make some sense in private law, but it's I think more controversial to say that in public law. And so I wonder if is there an underlying unstated normative commitment to judicial supremacy here that maybe needs to be fleshed out, or so. Second question. I get that writtenness is not necessary. I agree with that. Is writtenness irrelevant? So we tend to impute knowledge of the written code to legislators, but it seems to me to be a different proposition to impute knowledge of an unwritten code to legislators, even if just in degree. So I guess embedded within the question is there a kind of scalability to the lawness of a law so that it varies by writtenness or by some other factor? And it's not just binary, it's law or not law, but some things are more law than others.
Okay. So my question in some sense is, I guess in some ways a practical question, and I know you don't say exactly what the law of interpretation is or what its content is, but one of the things I was wondering is whether the law of interpretation varies depending on the branch doing the interpretation. And, or another way of saying that is, does the law of interpretation vary depending on what type of interpretive power the interpreter has? And, you can see in some of Justice Thomas's opinions from last term, right, suggesting that the judicial interpretive power is different from the executive branch's interpretive power. And I have an intuition that maybe there is a different law of interpretation based on my experience at government. But I was just wondering if you could say a little bit about
that. So I'll take a crack at the easy ones and let Steve do the hard ones. So I think sometimes the law of interpretation can vary. So different parts of the law of interpretation seem slightly different. So the things we talk about as like adoption rules, for example, or the linguistic rules, become part of the meaning of the legal instrument itself. They don't suggest any reason they should change from institution to institution, at least assuming that the executive branch and the courts are all part of the same like Hartian legal system, that they all believe in Santa Claus together or not. If they don't, we've got kind of bigger problems, which we might have, but that's a different question. What we call the application rules, though, I think some of them, like the rules themselves, might suggest different rules for different people. So a principle of judicial restraint might well be a principle of judicial restraint, but not a principle of executive restraint. Or the older canons about the extent to which judges had the power to know the intent of legislators or not was a sort of application rule about judicial power. Since the rules themselves, in a sense, have the institutions built into them, I guess you could say it's the same rule for everybody, but the rule itself says judges do this while legislators do that. But I think those are places where you'd see the most important differences. There is, however, you might just think, looking, you can see different practices in courts than in the executive branch. You might see like the courts cite, I don't know, one canon, and the executive branch cites another canon. And this goes a little bit also to Larry's suggestion, which I like, although I am intimidated by it. And I do think law, in the sense we mean, can be deeper than just what lawyers now think of as stare decisis. So the kind of general unwritten law we talk about, I mean, comes from the comes from cases, but it's often created by a course of practice. It's a sort of generally accepted custom. And so cases are the thing that produce it, but they might produce that in a way that's slightly different than just how holdings get produced under any of the existing theories of holdings. This is something I'm trying to tackle in a paper on liquidation that hopefully we don't have to prove to make this work, but it may be that we need to sort of go into some of that to explain some of this.
I would say a few things on the question is, so does it change depending on the interpreter? One point that I think we need to fix in the paper is a point that Richard Ekins at Oxford has made, which is that often laws are not sort of there to be interpreted by judges. Often the judges are just as much subject to the law as anyone else. They're just in a position of having to decide a particular dispute, and they approach the law in the same way that any private interpreter would approach the law, trying to figure out what it does. And in that case, a law might command judges to act differently than somebody else would, and sort of being restrained in certain ways or not. But in a lot of ways, the main body of the activity may not vary very much, depending even on official. And a lot of things we say in the paper we'll need to fix along those lines about sort of our application rules, instructions to decision makers. Well, some of them are, but some of them are just general rules. Contra preferentum applies just as much to the private readers of a contract as it does to someone given official power who has to decide what the contract means, and so on and so forth. On the stare decisis point, I agree with Will. A lot of the things that we're looking at are sort of, you think about something like the law of waiver. When have you given up an argument and you can't raise it on appeal? That is not well dealt with in a stare decisis way. I remember Judge Eichler for Judge Williams complaining about how courts seem to be all over the map on this, and yet they sort of know what they're talking about. They sort of have some sort of shared understanding of what's really going on here, and it may not be cash-outable in a sort of ordinary stare decisis way. It also may be the case that whatever theory of stare decisis you're looking at would need to be the legally correct theory of stare decisis, which might be different from whatever one is currently in practice just as much as the current law on recess appointments as practiced by the court might not be the law that you actually think applies. And that will depend on other theories of where this comes from. Caleb Nelson's demonstrable inconsistency theory or so on and so forth. You might have other claims about that. On the 2 points Jamal Green raised on publicity, I think the kind of publicity we're interested in, I think, is at a somewhat higher level. So it's that it's not just do people publicly state that X is the law, but sort of why do they state that X is the law? What are the grounds that they publicly accept and defend on which X is the law, on which you might get a greater degree of agreement and on which you might get widely shared claims that contradict what they actually say the law is. So, courts all up and down will say post, Noel Canning, X is the law on recess appointments. That might be wrong. The reason why it's wrong is because, on our view, they publicly accept and defend sort of higher order beliefs about the law that are inconsistent with that sort of object level, lower level claim about the law of recess appointments. And so the fact that they don't know the law is not necessarily threatening, any more than it's threatening that I would say less than 0.5% of lawyers know that it's legal for a one-armed man to possess a switchblade on a guano island so long as the blade is less than 3 inches in length. And if you give me time, I can show you the portions of the U.S. Code that actually say that. But the reason that we know it's the law, notwithstanding that if you ask somebody, hey, is this the law? Most people would say, like, heck no, that's crazy, is that
What's a guano island?
Right, is that they would be able to say, well, the U.S. Code is law, and if you find something in there, then that, so on and so forth. So the commitment to higher level rules can often provide agreement on things, so we might have more confusion about the lower level. The question of whether writtenness is irrelevant, in a lot of ways, yes. Written law obviously trumps unwritten law according to our priority rules. A statute will beat common law. But once we know that something is a rule of common law, it governs private interactions just as much as a written rule does, and we impute it in a lot of ways just as much as we impute written laws. We say that when when Congress passes a new statute, it does so presumably aware of all the unwritten defenses and so on, like duress and necessity and so on and so forth, in all their common law fineness. Now, the chance that they actually know of those things, that anyone even thought of them, is basically zero, as a claim about actual people's actual understandings. That's surely false. But the reason that we make that presumption is because the law commands us to. When we're adding this new statute into a legal system that already has lots of rules in it, the way that it fits in according to our legal rules is to, not impliedly repeal those rules unless it really, not to derogate from them unless it, by a fair implication, says so.
Guano Islands used to be a really big deal.
Oh, huge. Incredibly valuable. Wars were fought over them. That's why they're part of the special maritime and territorial jurisdiction of the United States.
Well, between the reference in Larry's article and this late discussion, that's a lot more batshit than I thought we were going to be talking about in this paper. Okay, our third trilogy is Chris Green, Bob Bennett, and Laurie Claus.
Okay. I don't have any episode 7 joke. I wanted to push back on, just briefly, on one of the moves that Stephen mentioned in his intro. I can't remember quite how you put it in the paper, but you said, well, we're not looking for linguistic stuff because we're not trying to figure out what was going through their heads. But Hillary Putnam, meaning ain't just in the head. So the new theory of reference, so Putnam, Kripke, but especially later Tyler Burge, there's this whole thing, semantic externalism, where roughly the idea, ordinary people, when they use a word like lemibnibum, some weird element, that what they mean is what scientists mean by that, and why couldn't it be like that with the law? So ordinary people, when they use ex post facto, they mean, whatever the lawyers mean by that, even though it's not going through their head, it's still linguistic. Why is that a sufficient motivation for jumping to this non-linguistic legal realm?
Next was Bob Bennett.
I wanted to ask about an elaboration of Raffles against Wickles House, the peerless case that you guys invoke early on. I'm sure most people here know about it, but this is the case of there being two ships peerless, and neither the buyer nor the seller of cotton, which was to be shipped on the peerless, is presumably at more fault than the other in leading to this failure for each of the two parties, the buyer and the seller, to understand that the other had a different peerless in mind. So suppose, as seems likely from the stated facts of the case, that the buyer's peerless arrives first. And the buyer goes down to the dock and says to the captain of the peerless, "I'm here to get my cotton." And the captain says, "We don't have any cotton. I don't know what you're talking about." And the buyer is actually quite relieved because the price of cotton has fallen, but he felt that he had to come pick it up because he had a contract. Now he finds that he had a different peerless in mind than the seller had, and the captain of the ship says to him, "Oh, now wait a second, who's your seller?" And he says, "My seller is seller." And the captain says, "Oh, he's got a different peerless that's scheduled to arrive in a month, but I think, you don't have to worry. The seller has an office right at the end of the dock here, and my pretty good information is that he's got some cotton here that he could supply to you if you just stop in and ask him for it." The buyer doesn't want any part of this because the price of cotton has fallen, so he walks by the office. He doesn't go in. It's proved at trial that had he gone in, he would have been able to get cotton. Now, I would think that the seller has got a strong case either to get his reliance interest or conceivably to have his interpretation of the contract, the writing they came up with, namely his peerless, governed, even though I wouldn't call this a law of interpretation. And moreover, it need not have been a law that was in any sense understood at the time the contract was entered into. What do you guys make of this?
Laurie.
Yeah, so to the extent the project is identifying the funding of the law of interpretation, not just arguing for its existence, I think we probably need to know a bit more about your theory of law than just the nod to heart, to deal with tensions and incompatibilities between practices of application and formally promulgated rules of application that might exist. So, if members of a formal institution that succeeds in law giving in lots of ways, lots of the time read Nick Rosencrantz's article, Federal Rules of Statutory Interpretation, and they pass an Acts Interpretation Act of the kind that exists in many other common law jurisdictions, and let's suppose it just doesn't change our practices much, right? That they pass this act, but in fact, we all keep developing our shared understanding the same way as we were before. Very little of the act actually seems to be gaining traction in the way that our disputes are being resolved and we're understanding our existing laws. We need to know a bit more about your theory of law to know whether, it's custom all the way down and therefore the act's not law, or, is there a theory of authority under which the act has a claim to being law?
Sure. So let me talk about Chris's point. Okay, let me start on Larry's point. So I think it's possible that we could have an Act Interpretation Act that would just fail to actually start guiding judges. It's possible that we could have a rule against drug possession that would fail in guiding drug dealers. The question is why we would treat those cases differently, and obviously judges are special in certain respects. But I think what would matter a lot, at least to us, and again, this might differ depending on your views of jurisprudence, is why are they not guided by it? Are they guided by it because when you ask them, they say, oh, that's not law, or they say like, well, it's law, but it's the kind of law that we're supposed to ignore under these circumstances, or it's to sweat, or it's et cetera, or if they say like, oh no, we are really following it, and just whenever you look at them, they're not. I think that there's a difference between law that's sort of widely ignored and something in practice, and law that is not even accepted as law. And so it would matter a lot on the details of the scenario, what exactly you're looking at. And we're planning on future work on, what do you do when you've got sort of very widespread conscious disobedience that's not public disobedience of law by official actors, sort of what Will's called the Illuminati problem, where it turns out all the judges are members of the Illuminati and are doing something very different than what we think they're supposed to be doing. On Chris's point, so it's possible. You're right about molybdenum. Raz has the argument about when people use the word table, they say any item of furniture that someone's supposed to put something on is a table. Someone responds, no, then if that were right, then a drawing board is a table. And they're like, oh, I guess you're right. And sort of, they're using the word in the attempt to cohere with the ways other people use it. And they sort of intend that it be understood that way. I think that what our account adds, though, is that it's not just I want this to be understood in the way that lawyers understand it. It's also that it's going to be understood in the way that law understands it, whether or not I'm sort of aware of all the legal rules. So that there is a difference between sort of a technical language and sort of legalese, and the legal process that has sort of secondary rules that apply to the outputs of a particular process and might produce an outcome that you're not necessarily expecting. We took out of the paper, though perhaps we shouldn't have, any references to Leibnizian modalology. Every paper, like more cowbell, needs more Leibniz. But I think it's probably not the correct view to say that every statute sort of exists in pre-established harmony with sort of the rest of the legal universe, that they sort of that the new statute sort of already contains within it as part of its meaning all of the things that it might need to otherwise interact with, so that a new criminal statute just already contains all the defenses, and so is not actually limited by other statutes involving criminal defenses, but never contradicted them to begin with. I think that you could come up with a theory of meaning that is rich enough to say, oh, no, all that stuff really is part of the meaning, in which case, and that might be Richard Dawkins's theory with respect to the intent of Parliament. And in that case, the two views might end up in the same place. But I think in the sort of ordinary way we understand these concepts, we're just trying to make the clear point that it's not the things that actual people are actually using. It's something very artificial and very different.
Yeah, so I'll, just two thoughts, or three thoughts, actually. I think some of this may just be terminology. So to the extent that people want to create a theory of language that is so thick that it includes everything we mean by the law of interpretation, we are as happy with that as we are to have the law of interpretation turned into the law of construction. I think, we see the language people over here and the construction people over here, and we're trying to get everybody to stop fighting. But to the extent everybody wants to agree on the substance and just stick to their own labels, that's fine. On the question of whether it's custom or authority, I guess I'm inclined to say it's a custom of authority. So the key is that our custom is to recognize that Congress can pass laws and people are supposed to obey them, and that custom is stronger than the custom we observe that drug dealers and everybody in California, as far as I can tell, don't obey the drug laws. And that sort of authority is still like Santa Claus in some sense. Like if we all stopped believing that Congress had any authority, I guess we'd have a revolution or go back to the Articles of Confederation or something. But the custom authority is what's important. I have no idea how to think about the peerless problem, which is why both of us are avoiding it. But my instinct is there actually would be something a little weird about imposing the liability without any pre-existing reason to believe that governed the case. Now, maybe there's some higher level legal rule we all kind of understand about sort of unclean hands that's related with what's going on there. We think the buyer is sort of forfeited whatever legal rights they have by engaging in obviously opportunistic behavior. But I'm not sure about that. I think the thing that the question I think drives home is a good reason to think that there are ways, we might have a view about how to resolve those kinds of intent misfiring cases that don't have anything to do with our view about like what the contract really means, or like which ship is the better peerless in some linguistic sense, and that we want to resolve that outside of what we think of as the linguistic domain.
Let me just interject real quickly that it's also the case there may just be more rules of contract law than interpretive rules that are at work here. So there may be like novations and sort of like new things going on that a court would have to take into account. In the same way, some of our closure rules, I think, are not fully interpretive in the sense that the rule that, whoever's burden it is to show jurisdiction loses if they don't is not an interpretive rule. It may involve interpretation occasionally when the question of jurisdiction comes down to interpreting a jurisdictional statute, but it's not sort of in its core nature interpretive. In the same way, it may just be that there are non-interpretive rules of contract law that come into play there.
I have to say something about the peerless case, just because I'm a contracts professor, so I'm like Bob. I get to say something now. I noticed the example, and I know why you used it, so I didn't comment on it. But there is a little problem with using it because you used it to make a point that was perfectly valid. But in the actual peerless case, not the hypothetical that Bob posed, the court found, possibly falsely, that there was a legitimate disagreement between the parties, and as a result, the contract failed. So it goes away. It's not a matter of enforcing the contract. It's like it fails. Now, it's been Gilmore said this was a failure of subjective meetings of the minds, and that's why it was crazy, and they shouldn't have done it that way. I think Holmes is right, actually, and pains me to say Holmes was ever right about anything, but I think Holmes was right. There was an actual objective ambiguity. The reasonable meaning of peerless there were two reasonable meanings of peerless. So now we would call this, in originalist theory, an ambiguous term. It had two meanings, even though the word was the same. They said different things. That's what Holmes says, and I think Holmes is right about that. It was objectively ambiguous, and there was no rational way to prefer one over the other, which is what all the default rules are there to do. Like if one person is aware of the other person's, well, that will be one way, and none of them works. So therefore, the contract fails. Well, you don't have that option with the Constitution. You can't say, oh, well, I guess you could have a knockout rule for constitutional provisions that don't apply anymore.
Ink blots, we call them.
Yeah, well, I reject the ink blot one, but I was happy he said it. But at any rate...
if there were, Amendment 28, all persons should have the right to a Snorlax, and we just have absolutely no idea what that is.
But in the normal run of things, there are ambiguities, and they may be unresolvable. And then I think that rather than let the Constitution fail for a lack of consensus ad item, which I think is irrelevant to constitutional interpretation, we have rules of construction that handle irreducible ambiguities and then allow for somebody to decide this according to what you would call rules of application. And so a default rule, so to speak, even when there's cases of irreducible ambiguity. All I'm saying is somewhat seconding Bob's suggestion that the peerless example might not, if you think about it, at the level you use it, it's fine. But if you think about it harder, it's not a great example of what you want to show.
That reminds me, Steve, you borrowed my Snorlax. I need that back. We have only 4 minutes left, so I think this next trilogy will have to be our final one. Cathan, Dick Fallon, and John Harrison.
So I definitely agree that the standard picture is not necessarily true of legal systems in general, and also that a lot of lower order American interpretive practice isn't consistent with the standard picture. But I think it's still possible that at least in certain limited domains, American law might incorporate the standard picture. So, you know, as Professor Fallon was saying, the constraint principle strikes many people as highly plausible. And I think that may be because there's this higher order legal commitment in the American legal system that whatever the communicative content of the constitutional text may be, that determines our constitutional law, right? So that would be kind of a limited incorporation of the standard picture. And so I wonder, you know, what you think about that. And it seems to me that if that is true, then that could have serious implications for whether originalism is our law, because if the fixation thesis fails, right, if it turns out that the communicative content of the constitutional text is not its original meaning, it's rather something like its current meaning or whatever, then our constitutional law would be non-originalist if the constraint thesis is one of our higher order legal commitments. And so it seems to me that, you know, you guys could maybe, I would be interested in hearing what you had to say about that possibility, because it seems to me pretty plausible that it might actually be true.
This is, I like the paper, and I like the problem that it's struggling with a good deal. My question relates to the law versus language point in the following way. A sort of simple-minded reading of the paper would be that when language is indeterminate, law resolves the indeterminacy. And it seems to me that the problem with that view, and I don't know how to solve the problem, but it's one that dogs me in many things that I think about. So I'm not just saying this is your problem, it's my problem too, is that law doesn't stand outside of language in such a way we can put law into one box and language in another box. So we could say, as Randy Barnett often says, the Ninth Amendment is a rule of interpretation. It's a legal rule of interpretation. Then we have to interpret the Ninth Amendment. And then law might give us more rules about how to interpret the rules about how to interpret the Ninth Amendment, but then we need to know how to interpret those rules. And so at some point, law and language begin to become impossible to pull apart in that sharp way. So I think it's hard to say that you can just separate law from non-law, and this is why it's a problem that dogs me. I think it's hard to say that you can just separate legal meaning from linguistic meaning, because at some point those two things are going to come together. Now, worried about this problem, it seems to me that one of the things that you try to do is to interject general law as a solution to the problem. And it's my instinct to think that that can work as a solution only if you define general law in such a way that general law encompasses, is somehow fused with language, fuses law and language as part of the culture or way of life in which educated people or legally educated people tend to think about things the same way, in the way that's necessary both for language to work and for law to work.
More Leibniz. There are two legal rules at the same level in the hierarchy that prima facie conflict with one another, and another legal rule at the same level in the hierarchy, you say this and I think it's right, but I want to know how it works, and another legal rule at the same level of the hierarchy says which one wins, and it's not all built in by preordained harmony into the content of the rules. How is that possible?
You have 1 minute to answer all three of those questions.
All right, I can do the first two in 30 seconds, and Steve can do the Leibniz. So to Ketan, yes, it's totally right that the law of interpretation could and often does incorporate something like the standard picture. In fact, that's part of what makes it not crazy. Of course, we most of the time just care about what the speaker meant, but the law has ways of sort of machining and sharpening along the edges. To Dick, I think it's totally right that a lot of the problem, like law itself is all just words, so it seems like we've got linguistic confusion everywhere. The advantage is that law has a lot more of these recursive formalisms that you were kind of alluding to. It has rules for resolving ambiguities. It has rules for resolving ambiguities and near rules for resolving ambiguities. It may be that it sort of turtles all the way down and there's going to be some linguistic confusion somewhere underneath it, but you got a lot of turtles, and I think that will sort out a huge number of the cases in a way that's just like gives us more tools than language has.
I actually, very quick on the first two, I think that often you have something that looks a lot like the standard picture, but you always have at the beginning of the analysis what community of content we're talking about, because there's always the possibility of more than one, and so like law is always in the picture from the beginning. Even you're never just using language in raw form. On the second point, I think that it is true that general law does help, not necessarily because it sort of encompasses language, but because the benefit of unwritten law is that you know what it is without needing a single authoritative linguistic formulation. So it's not that obviously we tell it to each other in language and we need to sort of be able to understand each other in order to do that, but you can have rules that sort of you know what their content is without needing to be able to specify them in a precise linguistic way. Finally, on the question of sort of two laws at the same level of conflict and the third one at the same level, I don't mean to fight the hypothetical. In some ways, sort of all of the laws are always at least written laws are always at slightly different levels, so long as they have different dates of enactment. But assuming that they're all in the same statute and so on, or they're all just rules of unwritten law, I think what you do is you try and give effect to as much of the law as possible. And you can give effect to the third rule only by ranking the first two in a certain way. Well, you know, I think that's that. You know, maybe
we're out of turtles.
whatever level you were thinking, +1.
All right, thank you so much to all three of you for a wonderful job.